But our top story remains Yakub Memon. A three-judge bench of the Supreme Court is hearing the mercy petition filed by the 1993 blast death row convict. This after two-judge bench was split on his plea seeking stay on execution. Well, there was a lunch break, but now we're being told that the hearing is still underway. Now the new bench will decide whether to stay the death warrant issued by the Tada court. It will also decide whether Yakub's curative petition will be heard afresh. With the hearing underway in the Supreme Court, the 1993 blast victim have also filed a petition with the governor. Yakub Memon has argued that his good conduct inside jail should be considered and that his death warrant was issued without exhausting all legal remedies. While the Attorney General has contended that Yakub has availed of all legal resources and options available to the death row convict are not really wide. All right, and joining me in the studio is Kapil Sankla, Supreme Court lawyer. Also managing editor Vinay Tiwari is with me in the studio. Joining me from Delhi is also Akhil Sibal, senior lawyer. But first up, let me go to you, Kapil. We believe that there has been a bit of a delay since there has been an intervention in this matter. Just take us through what that really means. Who is this intervener in this case and how could this affect the case and the hearing at this point?
You see, an intervener is a creature of law. Now, to any prosecution, there are two sides. One is the state and the other is the defense or the accused. An intervener in particular cases, for example, PIL matters, public interest litigation, or constitutional matters where questions of constitution or few other matters, a third party who's not a direct party, either the state or the defense, can intervene. So that is where the intervention or the intervener application comes in. Right. Now this third party can say that in a PIL that there's a larger interest involved and he should be heard, or that his interest or rights are being affected as the general public or as a body of people. So in this case, an intervention application has been filed by a university or a law college, I believe, and they are arguing on the law, on the constitutional validity of the death sentence that has been given, as well as the curative petition. So now if the intervener also is granted time to rebut or on the rebuttal arguments, that would also take substantial time, because I believe the Honorable Court has given half an hour to the defense to argue and half an hour to the learned AG to argue. So the question is, if the intervener also takes time, so that would substantially increase the time of the court and the decision that the court would arrive at eventually, because it would also have to meet the arguments put forth by the intervener.
Right. I believe Special Public Prosecutor Ujjwal Nikam is also joining us live. But before that, let me go across to Akhil Sibal. Akhil, what our reporters also told us as far as the hearing is concerned is that Senior Advocate Raju Ramachandran, appearing for Yakub in this case, initiated the arguments by talking about the split decision yesterday and also talking about how that is very crucial as far as this hearing is concerned, using it to the advantage of the counsel.
Yes, in fact, what seems to have happened is that this was not one of the grounds, if what I've read is accurate, that was raised in the petition that was filed, namely that the proper procedure for curative petitions to be heard has not been followed. This seems to have been a concern or an objection that came from the bench, and now that issue has sort of been considered and there's a split verdict on it, naturally the Yakub's lawyers have latched on to that issue and are pressing that issue, and quite rightly so. So that is the issue at the threshold. That is in a sense the first issue to be considered, because that's where two judges of the Supreme Court have differed, and thus the matter has been catapulted to three judges. One of the judges, Justice Dave, was of the view that these aspects of how the curative petition ought to have been heard, whether all the judges who should have considered it did in fact get an opportunity to consider it, are all issues which are irrelevant and meaningless, to use his language, in the order. And to his mind, once the conviction has been upheld, a review petition has been dismissed and a curative petition dismissed, not to mention the rejection of the mercy plea by the President and by the Governor. All avenues are closed, and to entertain yet another petition or a plea at this stage would be to make the litigation process interminable and open the floodgates. The other judge, Justice Kurian Joseph, was on the other hand of the view that when it comes to matters of the death penalty, which are irreversible and which deprive you of your life, matters of procedure cannot be brushed aside as being irrelevant or meaningless or of little import. They are critical, and all compliances must be made strictly because the outcome is to deprive somebody of their life. And therefore he was of the view that since the rules required that 5 judges, including 2 of them who were part of the earlier decision, should have looked at and considered the curative petition, whereas only 3 senior most judges instead of 5
Yes.
were given the curative petition to consider. Therefore it has to be considered afresh. So that was the short issue on which there was a split verdict, and that was the short issue on which the matter has now been put before 3 judges. So that will naturally be the first issue, whether that procedural illegality needs to be first corrected, and we need to have a fresh decision on the curative petition. That of course raises a critical question. If Yakub is able to get past that hurdle, that it would then go back to 5 judges, 3 of whom are already those who have said no once. So it would be critical as to what the other 2 judges, what view they take, and whether they are able to then persuade the other 3 to somehow either go in for a hearing before the court where lawyers are heard, or it's equally possible that the other 2 judges would arrive at a consensus with the 3 who have already rejected
Right.
it, and it would be a unanimous decision in chambers to say no.
Right, Mr. Sibbal, do stay with me because Mr. Ujjwal Nikam is also live with us. Mr. Nikam, the big question that a lot of people are asking, and the curiosity is growing by the hour while we wait for the Supreme Court judgment to arrive, is how is this going to impact the scheduled execution of Yakub, which is scheduled for 7 o'clock tomorrow morning. Of course, we cannot preempt what the judgment is going to be, but could you just take us through what the options really are?
See, frankly speaking, it will depend upon now 3 factors. Firstly, about the decision of the Supreme Court, firstly. Secondly, that is in respect of the mercy petition that has to be decided by the governor. And recently I came to know Yakub had also again filed second mercy petition before the President of India. So these 2 mercy petitions and again the Supreme Court verdict, all these things are interconnected with each other. Perhaps according to me, the governor of the Maharashtra is waiting for the decision of the Supreme Court order, then he may take the decision in the matter. I don't know, frankly speaking, about the mercy petition which Yakub had already filed before the President of India, because earlier mercy petition was rejected by the President on merits. But now Yakub alleged that earlier petition was filed by his relative, and therefore it doesn't contain the much material for the justifying why the pardon should be tendered to him. But now he himself had preferred that application under his own signature. But of course, according to me, that also raises a serious doubt about his illness, because all the while Yakub is claiming that he is suffering from mental illness, that is schizophrenia. Now how he can write his earlier application, and what are the contents in the earlier application, and how he can say that non-application of mind, all these things. So it is for the President of India to consider whether any successive mercy petitions to be entertained. Otherwise it will be an endless process.
Right, Mr. Nikam, do stay with me for a moment. Managing Editor Vinay Tiwari also with me in the studio. Vinay, we've got to know that there's been another mercy petition filed by Yakub as far as the President is concerned, and what it states is his good conduct. But isn't this a bit too late in the entire hearing process for him to actually go ahead with that as the basis for mercy?
Yes, and I think one of the facts that is being overlooked, and we've mentioned this in the morning, is that this particular case has undergone 4 judicial review processes. This is the 4th one which is currently in place. It's very unlikely that after you've already exhausted 3 review processes and the 4th one is being heard today, the President or the Governor will then take into account something which is actually a process which should have happened long back. Conduct is something that happens during your stage of incarceration, and that debate and arguments have already happened in courts before. So for that subject matter to come up now is a little tough to accept, whether they'll actually accept that plea or not.
Right.
Not just this, there are contradictory things that are being done by the defense. While one plea is talking about his good conduct, there's another one which pleads insanity or the loss of his mental health. So they're trying every trick in the book. But whether this really cuts much ice with the President's, the Governor's office and of course the court is doubtful.
Mr. Nikam, just taking that forward with you, these seem to be clear delayed tactics, not even less than 24 hours left for the scheduled execution of Yakub.
See, all the while Yakub is changing, of course his liberty had to do so, but he's changing from his ground, because earlier he had never agitated in respect of the composition of the curative petition, but only taking from hint from one of the judge of the Supreme Court. Again today he had agitated that issue. The Supreme Court will require to consider this issue. In my opinion, of course he is trying to stall the execution of death, and that is perhaps the worrying reason as to if such type of death sentence, which is supposed to be deterrent not only to the very criminal but to the like-minded persons, if it is being protracted for any reason whatsoever, then of course the very purpose of such deterrent sentence is frustrated. And of course, though it is an irreversible order, but ultimately the Supreme Court had very cautiously heard the appeal, again rejected review petition, again curative petition was rejected, President had considered on the merits, but again yesterday also one of the judges of the Supreme Court had hinted that even the Governor had rejected mercy petition, then he has the right to prefer the mercy petition, even challenge that order before the Supreme Court. So I have my own reasonable doubts as to how long this will go on.
All right, I'd ask our guests to stay. All right, we're going to go back to our top focus now, which is that hearing that is underway in the Supreme Court over Yakub Memon's plea. In the studio, in fact, we have a legal expert. We also have Akhil Sibal joining us live from Delhi. But coming to you first, Kapil, also what has happened in the Supreme Court today, one of the arguments made by Ramachandran is that the judges who were part of the judicial process earlier must be party to the curative petition. Right. Now, all that we're hearing in the Supreme Court as far as the arguments are concerned from Yakub's counsel only go ahead to indicate that there could be a possible delay in every action that really is connected with this case, especially the hanging which is scheduled for tomorrow.
You see, every big case, every case that comes in the limelight, every case that gets discussed becomes an important case for crystallization of law. In this case, what seems to be was that there was a procedural lapse or a violation, supposedly as put forth by one of the judges of the Honorable Supreme Court, in how the curative petition was heard.
And that's what they have to decide over.
And that is exactly what they have to decide over, because this question has been raised by one of the sitting judges of the Honorable Supreme Court. This was not a part of the pleadings made by the counsel of the defense, but this was suo motu raised by the Honorable Judge of the Supreme Court. So now there are two questions before the three bench today. One, whether the three bench would decide on this question which was not put forth by the defense in their pleading, and secondly, having so raised suo motu by the judge, whether this in fact is such a procedural violation or a lapse that vitiates the curative petition that was decided and has to be reheard by a fresh bench.
Right. Also, when I'm coming to you now, we've spoken about the basic defense by Yakub's counsel that's been presented even today in the hearing. Let's just talk about the Attorney General. What he has been saying is pretty much that, well, he's had enough of chances with his mercy petitions. Also that, in a way, he is connected to the 257 deaths. So clearly, they're standing firm on their demand for the hanging based on facts that they've stood firm over the last few hearings.
Yes, but that's standard prosecution stand. The prosecution, in their belief, and rightly so, have already established the guilt. Without establishing the guilt, the person will never get convicted. So the conviction has started from the Tada court, it's gone out to the High Court for ratification, because in every death penalty it has to be ratified by the High Court. It's then gone out to the Supreme Court. So each stage of the law has agreed with the prosecution that he does stand guilty of the crimes that he's been accused of. So I don't think there is any doubt in that sense about whether he was guilty of the crime or not. The only question currently, and some of the questions that have been raised the last couple of years have been, does this qualify? Question number one would have been, does this qualify as the rarest of rare? The courts have held it does, because that's why he's got the death penalty, which has been ratified several times over. And now, subsequent to this having been established, the decision and the arguments are clearly and only on the two technicalities. One, as Kapil mentioned, about whether the curative petition process itself was right, and the second about whether the issuance of the death warrant itself was correct or not. These are the only two questions right now that are currently being raised. All the other issues that are being raised about mercy petitions or whatever are really legal options, desperate options that any person on death row would raise.
Well, it is a technical issue like both Vinay and Kapil are pointing out. And let me put that question to Akhil now. Akhil, what the decision perhaps we are awaiting today and should be with us in a few moments from now, perhaps by 4 o'clock, could actually be a precedent for cases in the future?
Well, this seems to be the first of its kind where this kind of a question over lack of proper procedure being followed in the hearing of the curative petition has been raised. So to that extent, you know, it would set a precedent that in case the view is consistent with what Justice Joseph has said yesterday, then that would set a precedent that all the judges who are part of the decision which is sought to be cured must also take a view in the matter and be circulated the curative petition, and not just the 3 senior most judges. So to that extent it would you know, set a procedural precedent. And we must remember that in matters of criminal law, these aspects are generally interpreted strictly and particularly where somebody's life is at stake. So that's not an unusual approach. Hello, can you hear me? Hello? Hello, can you hear
Akhil,
me?
can you hear me? We can hear you. Can you go ahead with what you were saying?
Yes, I can. That's on the one hand. On the other hand, if the court rejects that view and chooses not to entertain it and endorses the view taken by Justice Dave, then the message that's being sent out is that, you know, there has to be a finality to these things. The courts can't be entertaining last-minute petitions all the time, and we must put an end to it and get on with the legal process. All remedies have been exhausted, and such pleas are really somewhat technical and last-minute attempts to delay the process. So these are the two possible views, and either way it would be a particular message that's sent out.
Right. Do stay with me. We have some news just coming in that you can see on your screen there. Arguments by both the defense and prosecution counsel have now been concluded. We are waiting for that judgment. It should be with us in a few moments from now. Perhaps it might just take half an hour or more. But Kapil, you said you had a point to make.
Yes, to add on to what was being said, in fact, the issue of curative petition has been discussed and has been laid down in 2002. The handbook of the cases and procedures of the Supreme Court, in fact, quote the judgment as we were already talking about Hora versus Hora, wherein what was said was that even after the dismissal of the review petition, the Honorable Supreme Court under Article 137 can reconsider the said judgment in a curative petition, which is in its inherent powers. So the inherent powers are very vast, are very large, but they would be the guidelines would be that to prevent the abuse of the process, to cure a gross miscarriage of justice, and in such petition can only be filed if a senior designate advocate certifies that it meets the requirements of the case.
All right.
Now after that, such a petition will first be circulated in chamber.
Yes.
And thereafter, before a bench comprising of 3 senior most judges and the 2 judges who had decided upon the main petition.
Yes.
And it's only after that will the decision be taken as to the curative petition.
All
so
right.
that was already being decided, and that has to be followed even today.
All right, I'll have to wrap up at this point, but that's the latest we're leaving you with. The arguments from both sides has now been concluded. We're awaiting that judgment. Hopefully it should be out in moments from now.